morning, everybody. Welcome to the Courtroom Files Live. Getting off to an early start today because it is a busy Monday morning out there in the courtrooms. Let's start with Judge McNally this morning.
You said, okay. You confused me when you said on behalf of the plaintiff. All right, this case was removed, and all we're doing right now, correct me if I'm wrong, is having a pretrial, right?
What we're doing, Your Honor, you actually helped us and you adjourned this for 2 weeks because Mr. Craig and the association and I have had some, you kind of gave us a directive to see if we could come up with some settlement terms. We do have the MSD hearing on the 21st, but I actually spoke with the board this morning and Mr. Craig. I don't have the terms finalized, but we do believe that we're going to have a settlement that will help remove this from the docket.
So what would you like me to do?
Well, Your Honor, if you need to procedurally set dates for discovery or trial, I mean, we could do that. I think they would fall off the docket. I don't know. I don't think that's necessary, especially with the MSD hearing scheduled as a safety net for the 21st. But I'll leave it at your discretion. I'm not prepared to put the term.
You intend to proceed with your motion for summary, right?
We actually intend to work with Mr. Craig to get a settlement and have him dismiss this action before we even need to have the MSD hearing.
Why don't I adjourn this a week?
I think that's great.
Okay, yeah. and that will give you two the opportunity to talk in the next few days. See if you can resolve it. If not, you're going to have to file a motion in response to their motion for summary disposition. Okay. So we'll talk about this next week. We'll make it again at 8:30 in the morning. I'm good then, right, Linda?
And if we were, I'm sorry, I'll wait till you're done, sir.
Next civil docket's on the 21st, Your Honor.
Well, let's do it on, what do I have on the 14th? We're going to do it on the 14th.
It's probation and
that's all right.
Okay.
I can fit this in. April 14th at 8:30 in the morning. Okay, sir?
Yes, sir. Got it.
And that's good.
Thank you, Your Honor. If we can submit, I mean, I'll work with Mr. Craig and talk to him. It's obviously, again, as the plaintiff, it would be either I guess we file an answer, so we'd have to do a stipulated dismissal. If we have that done before the 14th and submit that to the court, could we update the clerk and not have to appear on that date, or would you prefer?
Yeah, of course. Just make sure we get your paperwork before then, and that you put in a phone call and say we got a stip in order for the judge to sign.
Okay.
Okay.
Okay, Mr. Craig.
Right, otherwise we'll see you next week at 8:30. Okay. Thank you.
Thank you, Your Honor.
Good luck. Velocity versus Tracy Stewart. I'll recall that. 2402631. Mr. Strauss.
Yes, I'm here, Your Honor.
Appearance.
Gary Strauss for Mr. Stewart, P48673.
Maxwell Quinn, P86016.
Any resolution, gentlemen?
We have not reached a resolution. We're just going to need a scheduling order. We should be able to settle this one.
Discovery is permitted until June the 7th. No ADR. No motions dated trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury. I'm not going to have a settlement conference, Linda. I'm going to have 1 hour on this for a trial, and you're going to give me a trial date for let's see. Oh, geez, this is old.
Really?
This is really old. Why is this so old? I'm going to set a trial date in, actually, I'm going to give you until discovery cutoff is going to be May the 21st. All witness lists are due by April the 21st. You don't have to file a trial brief. In the event you choose to file a trial brief, it has to be filed and exchanged not later than 7 days before the trial date. Get out your calendars, please, gentlemen, because I'm going to give you a trial date, and this case is nearly a year old. I'm not gonna be able to adjourn it, so make sure you're available. Give me one the end of June, Lisa. Linda, geez.
Hey, Your Honor. I don't know if it matters, Your Honor, but I think our answer was due in February.
I don't know what happened here,
8th?
but
I
there
don't
was
think it's
all
that old,
kind.
is it?
July it
Huh.
was filed of 24.
Huh.
July of 2024. I'm gonna have to have this done in a year.
Really?
Your Honor, is June 17th, is that a good date?
Yep. What time?
10 o'clock?
At 10 a.m. I don't know. There must have been extensions on the service.
I don't. Huh. Let me see.
It was
Yeah, I've
filed
seen a
June,
second
July
stump.
16th. It was filed July 16th. So trial, is everybody good June 17th at 10?
Yes.
Yeah, it works for plaintiff.
Okay, so that's what we'll have. And I'll send this out. You should have the scheduling order. So again, discovery cutoff May 21 and witness lists are due on April 21, okay?
All right,
Thank
sounds
you.
good, Your Honor. Thank you.
I mean, it
Great.
looks like a pretty straightforward collection matter, but that's what we'll do. Okay? Thanks,
Thank you.
guys. Have a good day.
All right, too.
Same to you. Thank you.
Citibank. Hang on a second. What happened to the? Citibank versus Diane Kelly. 2404885. Good morning. I'm
Good
sorry
morning.
I didn't see you there. Your name?
Diane Kelly.
All right, Mr. Sherrill, are you here for Citibank?
No, Performance Equity Partners.
Okay. I called another case. Who's here for Citibank versus Kelly? Mr. Groan's office out there, Linda?
I don't see him, Your Honor.
I've never seen this so much.
Nope,
Don't
I
get me
don't see
going.
him. Yeah. Do you want me to call him?
I don't think we need to be their secretary anymore, to be honest with you. I
I
think we
know.
have enough to do. It's just ridiculous how many times I see people not show up. Bank of America, I'm sorry. I'm going to give you about 10 minutes and then I'm dismissing the case. Bank of America versus Heather. Have a seat, ma'am. Heather Martin, 2500048. Good morning, Mr. Barta. Your appearance?
Good morning, Judge McNally. Sazan Barta, B65425 on behalf of Bank of America.
All right. Do I have Heather Martin here, Linda?
She was here. I don't know where she went. I had her checked off. She was, oh no, no, that's not her. I don't see her now.
Was she ever out there?
Yeah, I had her checked off. I don't know if she was in the, ask John if she was in the courtroom.
There's nobody in the courtroom. No.
No.
Well, she was out there. I think, do we have a phone number on her? Do you have a phone number on her, Mr. Barta? I'd like to at least call her if she was out there. Maybe we just lost her.
I do not, Your Honor.
I'll look on the paperwork, Your Honor.
Well, Judge McNally goes on a missing people search. Let's say good morning to Judge Meineke.
That judge, I think, establishes growth. He's been excellent on bond. There's been no issues involving that. He also voluntarily did a victim impact panel. We thought that was something appropriate, even though this isn't a driving issue. And also he has completed the paperwork and signed up to do some volunteer work. And ironically, they assigned him to expungements. So he's going to be assisting the expungement. I think it's the Michigan I'm not sure if it's Michigan Indigent Defense Council, but I'm sure Your Honor knows the program I'm speaking of. He's going to be working on the expungement program. Quite frankly, I don't think there's a scenario whereby a person involved in something like this knows more of how devastating this could be, both personally and professionally. But I am impressed with him. I am pleased with him. I've stayed in constant contact with him, and I think he is doing his very best. And I believe, particularly with Mr. Smith's help, I believe this issue is going to be resolved, and he's going to move forward and continue in a healthy lifestyle.
Thank you, Mr. Compton. Mr. Bertucci, to the reduced charge of public nuisance, do you plead responsible?
I do, Your Honor.
All right. Mr. Smith, any comments that you'd like to place on the record?
No, I would agree with his attorney, Mr. Compton, and especially the part that he is engaged. He does not use his profession or title as any kind of an advantage in the group. If anything, since everybody in the group has an attorney and is therefore an alcohol-related offense, they could be intimidated by someone of the attorney background. But he's humbled. He's working the program as we outline it. And I anticipate that he will be part of us in terms of treatment for at least a year, if not more.
I'm hopeful for that, Mr. Smith, because, you know, I certainly feel I felt a lot more comfortable. And again, I wasn't his judge during his sobriety court period of time, but I know that's a couple of years of work that's put in. And obviously, I'm sure Judge Wittenberg and Ms. Clark, who's here, had a lot of confidence at the end of 2 years of work. All right. So I'm hopeful, Mr. Compton, that these 60 odd days have started him back on the path. But like you said, it's going to be up to him just to continue this. I can't put someone on a civil infraction on probation. There's nothing I could do more than fine Mr. Bertucci. The only thing I hope is that this opened his eyes as to the reality that there is not a day where he's going to be able to drink. There's not going to be a time where he's got it figured out. That this is, it's when it comes to him and alcohol, it's over, and it's over for good. And he has to make sure that there's enough plans in place so that if he gets into tough times, tough moments, that he has many other positive outlets, phone numbers to call, people to reach out to, so he's not in this position ever again. You know, I'm hopeful, but as you can imagine, I'm not nearly as secure as I was when he completed 2 years of probation. He's done enough to get a reduction. He hasn't done enough to sort of, you know, restore the confidence that this court has. But at the same point in time, I remain hopeful because I mean it when I say this. Mr. Bertucci is at his core a good person. But Mr. Compton, we've seen lots of good people that have not been able to manage this challenge effectively, and we've lost them, and that's unacceptable. Just frankly unacceptable. So it's the order of this court that I will sanction him the $500 that has been agreed upon. There's nothing more that I really can do. I'll give him 2 weeks time to pay. I hope that he follows through on all these things because he's not going to be required by some court to do it. My hope is it's just his own personal decision that will drive him forward. I mean, the other thing too, Mr. Bertucci has to deal with the fall. I mean, I think the house that he was banging on was his neighbor, so now he certainly has brought this issue to their world, and so both both for himself and for his local neighborhood. I think it would be important just to stay on top of all sobriety efforts. Mr. Vitucci, I don't really need to hear anything more from you. You said you put responsible. I just need to not see you here again. And if I don't see you here again, it means that you are more than likely taking care of your sobriety. If I do, I find it very unlikely that the prosecutor will give a reduction again of this nature. And I find it very unlikely that the court will consider a probationary term going forward. So, Mr. Vitucci, a lot of people are betting on you, and they have good reason to. And I think you'll deliver. Good luck.
Thank you, Your Honor. I appreciate it.
Thank you. Thank you, Mr. Smith, as always.
Thank you, Your Honor.
Thank you, Judge, again. Appreciate you.
All right, let's head back to Judge McNally's court. Maybe they found the missing person in our... Looks like they're moving on now.
096. Mr. Kraft out there, Linda?
No, Your Honor, he never checked in.
Okay, you can go ahead and if you'd like, counsel, and take a default on this, just give me the breakdown, principal sum, each of your costs, and we'll go from there.
Yep. So the amount prayed for in the complaint was $5,459.60. So 5,459.60. JP Morgan Chase doesn't charge any costs or interest, so that's just the amount of the judgment.
Okay. Go ahead. You can take your default judgment. Defendant failed to appear. This was scheduled for 8:30. It is now 9:14. Default judgments entered in favor of the plaintiff and against the defendant in the amount of 5,459.60. Have a good day. You're all set. Thank you very much. Take care. Do you have another one?
Yeah, I have Citibank versus Webb.
What time's that?
That one was set for, I think that one was 9.
We'll find that while I go on to another one here. James
No
Sherrill, I got your case. Performance Equity Partners versus David Fry, 2500325. Your appearance?
James Shirley for plaintiff.
Mr. Fry, your name?
David Fry.
All right, so Mr. Fry is here. This was a motion for possession pending final judgment, right?
Correct.
All right, so what would you like to tell me? Did I signed the order initially, the restraining order, and then I see we had it up for February the 24th. Can you enlighten me?
It was adjourned to 2 weeks ago, Your Honor, at which point the court adjourned it one more time.
Okay, so we're just here to decide the motion for possession?
Yes.
All right. What?
I was ordered to make the payment within the last 2 weeks, and I tried to get a hold of them on Friday and make the payment over this weekend or on Friday, and their office was closed, and I tried to see if there's any way I have all the money in an account ready to make. All they got to do is click the button.
Oh, well,
that's it. I'm trying. I tried.
Hang on, slow down.
Yeah.
Slow down. Do you know, was your office closed Friday?
Plaintiff's office. Plaintiff's office closes at 4:30 Central Time on Fridays.
I see. So why don't I put you two in a breakout room? Okay, Mr. Sherrill, and you talk to him and you guys can coordinate this. Either way, I want you to come back in front of me. We're going to put you in a room to speak to him online. All right?
Okay. All right.
Thank you. Thank you.
Thank you.
Mr. Barta, in all this excitement, I forgot which one is yours. I got Bank of America versus Heather Martin.
Let's switch gears and go over to Judge Simpson's court. He's doing a landlord-tenant docket, but they actually have somebody on the witness stand, so I'm curious what's going on.
Yeah, the second notice, the first notice on the housing commission was April 24th, 2024. So they had April, May, June. They had 3 months to do the repairs.
Okay. Anything else? No? Any questions?
I have a question, Your Honor. At one point, you mentioned something about your oven or stove. Can you say more about that?
Yeah, the oven almost got moved to catch on fire. I called Nick Nancy. to come fix it. I have background to that too, but, they never came, so I had to go get the stove myself.
You installed the stove yourself?
Yes.
And I understand, so it sounds like there was, with the flooding that you were describing, was that sewage water?
Yes, it was.
Okay, and what floor were you on?
I was on the, main floor. And, it wasn't from, when I first moved in, Stacy was trying to tell me it was from the main, upstairs, because they would always say flooding. I did have somebody come and investigate it, and I did pay him $300 something to look at it. Then he had to come back and he told me that, then he'll come if he has to, but, they told me that the issue is bigger than what can be handled. That I was wasting my money to address this, to call somebody and see what we could do about it. And I did, I started calling, a bunch of people at, Housing Commission, I was calling them. This is not, this isn't new, it's been an ongoing situation.
Were there certain times of day or anything where the flooding would occur?
When it rained, it was worse, but sometimes it would just happen. You can't control it. It's coming from wherever the issue was. That's where it was coming. Why did it come? It came. Like I said, I went through 3 steam cleaners.
You were on the first floor.
That's correct.
So were there 2 floors on top?
There's my floor and then one more floor.
Okay, because there's sort of a basement, right?
The laundry room was always flooded.
What was the water?
The other sewage.
How do you know?
By the smell. It was awful. It's awful.
Was there anything visibly noticeable about it that you made it look like sewage?
Yeah. Yeah. It was sewage. Doesn't take much to drink it out. It was just rainwater. They caved the whole ceiling.
Which part of which ceiling?
When you walk into the door, my front door, right there. I have pictures of that too. It's all over the internet.
Did you have, I mean, that's obviously a huge issue. Were there other issues as well? Like, did you have
I had issues.
hot water consistently?
No, they have hot water. Sometimes I didn't even have, I have letters that they sent out. They gave us little heaters. They never addressed anything, nothing.
Your Honor, I understand that the city inspectors have some photographs of when they inspect the unit and send it.
This unit?
This particular unit. And so I'm just, I guess I would defer to the court on how and when you would like to.
Well, I'll hear from them.
Okay.
Is there any other questions you have for Mr.?
I'm kind of curious about her installing the stove.
Go ahead.
Did you have somebody install it?
Yes.
Who installed it?
My friend, his name is James. And they wanted to get me a stove. There was a couple people that had stoves in there.
You didn't have it for.
No, I wish I did.
I do have another question, Your Honor. So my understanding of vouchers is that they use them or you lose them, they expire.
That is correct.
Do you know when the expiration date is for yours?
June 2007.
I'm sorry. Do you know when you have to place it? I might be misunderstanding. When do you have to place it by before you lose it?
June 2007. So when I had to use about the housing voucher, yeah, I just have to find a place, but it expires 2007. If I don't find it,
is it 27?
Yeah, 2027.
So my experience is that they typically will go for 3 months and sometimes are extended to 6 months.
That's correct.
In extraordinary circumstances, maybe a little bit longer. Do you know why yours would be so much longer than that?
Probably because of the situation.
But you're sure you're sure that you have your
Yes.
voucher?
Yeah, I talked to, Gracie, well, I talked to her in December.
Right.
When we were going to court, and then I just recently talked to her, because I asked her, I said, what am I supposed to be doing? She told me, just keep coming here and.
Okay,
do what-
so,
And, what is preventing you from finding another place?
It's hard to find, it's really hard.
Do you think that the judgment might be affecting?
Oh, yeah, it's affecting a lot, because I mean, they wanna know, they wanna make sure that if they're renting, they just don't wanna rent to somebody. That's basically what they say too. What was the reason? I give them all kinds of reasons, but it's just my word.
so ma'am, where are you living right now?
I've been back and forth, pretty much, I'm just couch cruising, but my mom was sick, so I was helping my mom.
I guess I would just ask to keep the record open on her particular cases. It sounds like she might have photographs that would be relevant. You can meet with her at another date, Your Honor. With other questions.
Yes, so I guess I have a question for you, Mr. Raymond. Why shouldn't I order that she be rehoused?
I think that's up to your discretion, Your Honor.
Oh, I know, but I'm asking, I mean, my inclination is to order that she immediately be housed. So is there any reason I shouldn't order that?
I'm going to leave that to your discretion, Your Honor. I would say though that I'm not being argumentative here, but I'm not sure that the decision to not allow dismissal is doing her any good. It could be without prejudice to her having some claims. So I don't think that the case, the judgment against her, I don't think is working in her.
You mean the judgment that should have never been?
That was not a judgment that I entered, so I'm not going to.
Okay, but you mean that judgment that should have never been? Well, Mr. Friedman, you and I have both been doing this for a long time. I know that when landlords want to escape something that they've done, what they do is they file against people, and then all of a sudden, when things start to look bad, they want to dismiss them. It wasn't by accident that I didn't allow these cases to be dismissed, because the moment I would have dismissed her case, she would have never gotten here and told me that because of the circumstances at Arbor One West, this is the court's interpretation of what she's told me, led her to become homeless. And then I could then sympathize and empathize with her, but I could not do anything about it, like what I'm about to do, which is I'm going to order that Arbor One West rehouse her immediately. She is to be rehoused within the next 5 days.
Your Honor, would the court consider setting aside the judgments that were previously entered?
I'll consider that at a later time. Right now, I want her in housing. She should be living like she's living. Okay?
Your Honor.
What I'm going to do is I want to have you talk to the folks at Legal Services. They'll operate through Legal Services in terms of her rehab.
So if she wants to give her contact information and everything to Legal Services, we can work through them, but we don't have any contact information for her.
That's because she had to move and she's homeless. I get it. So that's why I'm going to ask Legal Services to help her with this. Okay, Ms. Griffin. All right. We're probably going to need you back for other testimony and everything, okay?
Yeah.
All right. Thank you.
Thank you.
Never mind.
Okie dokie. With that testimony having been concluded, I'll try to keep an eye out for if that progresses. Landlord-tenant's a little hard to follow, though. A lot of that happens through motions and stuff outside of court, but I'll try to keep an eye out, see if there's any updates. Anyways, let's go back to Judge McNally.
Lawyer?
I'm sorry,
Do you know
Your
for
Honor.
fact
That's Bentonville, Arizona.
Do you know for a fact that he's a lawyer?
No, Your Honor, I don't.
I don't want to ask you how much you paid to Derek Williams. You might want to check into I don't know what went on. But if somebody is a lawyer and they're listen to me.
Okay.
If somebody's a lawyer and they're taking money and monthly fees and not working on it, if what Mr. Barta just told me is true, and at least the notes in the computer, I believe, his computer, I believe, would be true. In other words, well, I can't say that, but unless somebody neglected to put something in and Mr. Williams got a hold of them and did not get a hold of them, let me rephrase that. If Mr. Williams is a lawyer and he took your money and told you these things and didn't do anything on the case, and Mr. Barta's records at least reflect they were never contacted by a debt settlement company. Does it say who the debt settlement company was? You said in January they told you that, right, counsel?
Yes.
There's a note. Was that a law firm or a debt settlement?
Let me go back to that note.
If a lawyer did that to me, sir, and he's a lawyer, I would file a grievance with the Attorney Grievance Commission in the state where he practices, if he's a lawyer. Okay? They can't just take your money and not do anything on the case. And I'm just telling you, if that's what happened, I'd encourage you to consider filing a grievance against a lawyer with the state bar in his state. Now, if it's not a lawyer, you've got other issues. Well, but if what you're telling me is true, if what I'm hearing is true, somebody took your money, charged you a monthly fee, told you not to contact creditors, according to Mr. Barta, never contacted them in 2 years. I mean, that isn't the kind of guys we want walking around practicing law.
Well, Your Honor, they also took care of 3 other outstanding debts that I had.
Well, that's fine. That's fine. I don't know the whole situation, but that's fine. But I'm going to decide this motion for summary disposition now, and you can go ahead and you're just saying you shouldn't be charged for interest from February 23 to the present. There's no law that says that. I can't just say, well, wave a wand here and say you don't have to pay because you turned it over a debt consolidation company or a lawyer or whoever else. What was the interest rate on this, Mr. Barta?
Pulling it up now, Your Honor. Uh, 26.99%.
Yeah, see, that's the problem. We shouldn't be getting credit cards at 26.99. Now, I understand we run into financial trouble now and then. But if they're charging 26.99, that's a losing deal, right? I don't know what else to tell you. What would you like to say on this, Mr. Barta? I mean, I don't see any affidavit saying it's not owed. There's no, you needed to file a counter affidavit. You can't just, Mr. Parent, no disrespect. You can't just say, I don't have to pay the interest because I turned it over to a company to negotiate the debt. So unless you can tell me that debt didn't amount to that amount, I have no choice. And I'm talking about 19-608-13.
Okay, Your Honor. It is what it is.
You want to say anything, Mr. Berta?
No, sir.
Based on what I see in the motion, I find there's no genuine issue as to any material fact. I'm going to grant summary disposition, as much as I hate to do this to you, at that rate. 19-608-13 in favor of the plaintiff and against the defendant. Do you want to give me a summation of your cost, please?
Yes, the damages is 19,608.13. Filing fee $164.80. Service fee of $44 and a motion for summary disposition fee of $20 for a total amount of $19,836.93.
So I'm going to grant your motion. I'm sorry, sir. I can do that. I'm going to have to give him a judgment. I want you to understand, I can set up a motion for installment payments. Here's what I'm going to suggest to you. Are you still working?
Actually, no, I've been laid off.
Well, if you want to file a motion for installment payments, I'd suggest you come up to the court today, get one of those motions, fill it out, and I'll set it for hearing. And then I'm going to determine how much you can reasonably afford to pay weekly, bi-weekly, or monthly. And they can at least garnish wages during that period. They can still garnish bank accounts and tax returns, but they can't garnish wages. So I'm going to invite you to do that. That's the best I can do for you. Okay? Do you understand everything that's gone on here, Mr. Parent?
Yeah, I do, but I don't think it's right.
Well, what part's not right? I can't just make my own laws up here. I mean,
no, I understand, Your Honor. I know your hands are tied.
I don't think it's right either that they're charging that, but then again, we're all adults, and when we enter into an agreement to pay that, you know, sometimes we got nobody to blame. I feel bad that you did that, to be honest with you, but
Your Honor, is there an order? Is there an order attached to the motion that you've signed, or do you need me to submit an order?
I'm going to need you to send one. I didn't see one in the packet. I'm sorry.
I'm good.
Okay, thank you very much. Have a good day, Mr. Parent. I sincerely wish you well, sir.
Okay, thank you, Your Honor.
Where's that?
Yeah. Okay, Corenda, am I pronouncing that right, Corenda? Yeah, I think part of this issue is it sounds like we came in the middle of this, but it sounds like this guy was working with like an attorney or a firm to try to do some kind of debt reduction or consolidation, and they were like handling him fraudulently. That's what it sounds like to me. I've already made a note. I'm going to go back and look at this afterwards, and if there's something there, I'll do a separate video on that. So, yeah, we'll see what's going on. Judge Fleischer has now come online, so let's go say good morning to him.
Violated. It's the GPS exclusion zone. He has a GPS device with a curfew as well as an exclusion zone for the 12,000 Martin Luther King Boulevard address.
Okay.
However, it also seems to be the residence of Richard Collins.
Okay. Have you guys done a rip on this case? Do you know?
I believe we've attempted one, Your Honor, but we've not made contact yet. Or I'm sorry, I apologize. We have made contact now, Your Honor.
What does she want? Does she want to have contact with him? Does she not want him to go back? Mr. Frederick, do you have the ability to hire a lawyer?
No, I don't.
Okay, I'm gonna need you to fill out an application for me. I need to know whether you qualify. We don't just give out court-appointed lawyers like it's candy. You have to qualify for it. So what we'll do is Deputy Miranda's gonna give you an application. I need you to fill it out. I need to know everything about you, what money you have in the bank, what kind of money you make, what kind of job, cars. Let me take a look at it. I'll see whether you qualify. Do you currently have a monitor on you now?
Yes, I am.
Okay, you are not allowed to go back to this house. I don't know whether she wants to have contact with you until I know. I'm going to honor these bond conditions. Do you understand?
Yes.
Okay, so let's first see if you qualify for a lawyer. If you do, I'll give you a lawyer and then we can go further. Deputy Miranda is going to give him the application. I'll have you sign a reset and then we'll have you take a seat in the jury box.
Go ahead.
Your disability, like you said, they were living together and they no longer live together. I'm not sure if that means she moved out of the residence and she lived in a residence.
See, maybe we can get it done a little bit later today.
Yeah, sure. This is a community,
Judge, you ready? So we have a couple more. Hi.
One, I don't think I've ever seen you not in a bow tie.
Yeah, it's few and far in between. What?
So this is, I talked to our conviction and integrity unit, who's sending out the letters and the notices to the individuals that have wrongful conviction.
Right.
And what we're doing is, of course, the ones that are inside 30 days, and we can just come to court and fix them. When they're outside 30 days, what's happening is they're either hiring a lawyer to file a writ that's unopposed.
Okay.
Or they're being appointed a lawyer.
I'm happy to appoint all of them because it's our mistake, so there's no reason for them to have to use money.
All right, and they're going to be unopposed.
Okay.
So it should move very quickly. I know it adds a case on the docket, but they're.
I don't care. It doesn't matter, really. It's nonsensical to get up in arms. So the idea is that we streamline it so that we know we have it,
Yes,
deal with
sir.
it fast, so they don't have to take a lot out of their time
Yes,
to
sir.
deal with it. So I guess what I'll do is I'll start letting you know when we have one come in. Is that all right?
That would be great.
Okay.
And then we could do it, like I said, we could do it unopposed. There's no, as far as I'm concerned, of course, it's up to you, but we don't even need them to appear in court. We can just do.
Okay.
Just get it done.
The one we have on here on Friday has a bunch of open cases now. So are we still going to do it the same way?
Do it the same way, unopposed, and just move the case.
Okay.
Thank you, Judge.
We're waiting on him to file a motion for new trial. Once he does, then I'll send you notice.
Thank you. Thank
Okay,
you.
great.
Thank you, Victoria.
Okay, thank you so much.
Yes, sir. May I be excused, sir?
Thanks for coming.
Thank you.
Page 11. Hernandez, Ernesto, come on up. Good morning, Judge. Buenos días, señor. Yo soy su intérprete. Me parece que conteste todo a voz alta.
Okay.
You are Ernesto Hernandez.
Hernandez. Sí.
Yes.
Mr. Hernandez, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, será
You
usado.
have the right to have an attorney represent you. If you cannot afford one, one will be appointed to you, sir. Okay.
Judge,
Nada, escuche.
on March 31st, 2025, in Harris County, Texas, law enforcement officer was flagged down by the complaining witness who stated that a vehicle was driving the wrong way down a one-way street and damaged the complaining witness's vehicle and did not attempt to stop. The complaining witness stated he followed the defendant to a dead end and called the police, then found the law enforcement officer. The complaining witness then showed the law enforcement officer where the defendant's vehicle was parked. The law enforcement officer found the defendant asleep behind the wheel of his vehicle. The complaining witness was able to identify the defendant as the individual who was driving the vehicle at the time the damage occurred. The complaining witness estimated the damage to be $800 to $1,000.
Estimaron que el daño, I'm sorry, the amount
$800 to $1,000.
entre 800 a $1,000.
So he hit the vehicle and
Así
took.
que él le pegó al
Yes,
vehículo
hear that. And how far did he go?
y que tanto
I'm not
siguió.
sure.
Dice, no estoy seguro.
It occurred near
Eso ocurrió cerca de
340 South 69th Street.
342 Sur,
And then there
calle
was a dead
69,
end
entonces
at
una calle sin salida,
the defendant was parked at
donde
300
estaba
South
estacionado el
7th
acusado,
Street.
cerca de la calle 70.
Read the part where the accident,
Dice,
please, if you
lea
don't
la
mind,
parte
into where he took off.
cuando tuvo un
Yes,
accidente
sure.
hasta dónde.
I didn't hear it.
Complainant stated a
El
vehicle was
denunciante
driving
dijo
on
que
the
un
wrong way
vehículo
of
iba
a
en otro
public
sentido
roadway
en una
that
carretera
is a one-way
pública,
street.
que era una calle de un sentido.
And the complainant stated the defendant
Dijo que el
damaged
acusador
his
dañó
vehicle
su
when the
vehículo
defendant was driving the wrong
cuando
way and did
estaba,
not attempt to stop.
cuando estaba
So
manejando
it has
en
the
una vía en
difference, Your Honor.
contraria. Entonces no paró de información.
And then he goes to a dead-end street
Es una calle sin salida.
Yes, Your Honor.
Sí, sí.
and falls asleep.
Yes, Your Honor.
Do we know if alcohol is a factor?
He consumido
It's not
alcohol.
alleged, Your Honor.
No se alega eso, su señoría.
I'm not sure that there was any
No estoy
investigation.
seguro si hubo una investigación.
Mr. Hernandez,
Señor
I'm
Hernández,
if there's
voy a
sufficient
encontrar
probable cause to go
suficiente
forward.
causa para seguir hacia adelante con su caso.
On his license, please.
Yes, Your Honor.
If you do not have a Texas driver license and liability insurance in your name, you are not allowed to
No se le
drive.
permite manejar.
Do you
¿Lo
understand?
entiende?
If I find that you do,
Usted
I will put you in jail.
vamos a meter a la cárcel.
His license is eligible.
I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you,
No
they
encuentra
can possibly put a detainer on you and you will be stuck like Chuck in there
como yo.
until this case is over with. Do you understand?
¿Lo entiende?
It
Yes.
is a bond condition that you're not allowed to drive unless you have liability insurance as well. Do you have the ability to hire a lawyer?
Has de contratar un abogado.
Sí, contraté uno.
Yes, I hired one,
No, no ha llegado, yo creo, no sé.
but he hasn't gotten here. I don't think so. I don't know.
Oh, Judge,
I
they
don't
called
see
this morning and they said that the attorney had to go to a different court, but he was going to be on his way. And
Do they
thought they were
identify
following up.
who,
La oficina.
see anything filed
Yes,
there?
yes.
Oh, you do? Who is it? 'Cause I don't see it. That's
It is Mr. Pass.
David Potts. Okay. So what we'll do now, Mr. Hernandez, is I'm going to have you sign a receipt, Victoria. We will have you take a seat at the jury box while we get your bond conditions. We will also wait until your lawyer arrives.
Su abogado.
Please, do you mind filing no driving without both?
All right, well, he's between customers, a little more formal good morning now that we're 50 minutes almost into the stream. I did start early this morning. Welcome to the Courtroom Files Live. Happy Monday to all of you. It is a fairly busy morning, but I'm going to ride with Judge Fleischer for a little while because a couple of the courts that I'm monitoring that I would want to switch to have actually gone to recess. So we'll stick with Judge Fleischer. By the way, I think this is on YouTube's end, but YouTube is trying to tell me that there's stream quality issues, but everything I see says the stream is fine, and on another computer, I keep this stream running as like a customer so I can see it and everything looks fine. But if anybody's having issues with buffering or something like that, let me know in the chat. Otherwise, I think they're just lying to me. Let's get back to Judge.
Shape. Or no, I'm sorry.
Yeah, that's it. Shape.
Judge. On March 30th, 2025, in Middleton County, Texas, an officer was dispatched to a family disturbance call. The officer met with the complaining witness who stated that the defendant is her husband. The complaining witness stated that the defendant and her son, who has mental health issues, got into an argument where the defendant slapped her son in the face. The complaining witness then intervened by getting between them. The defendant then grabbed her by her hair and pulled it, causing pain. The defendant then left to the garage, saying that their children would grow up without parents.
Judge, if I may, they did a rip call, and in the rip call, it indicated that she didn't feel any pain.
Judge, let me clarify, what the rip call says specifically is that she got in between them and he grabbed her hair a little bit. The complainant was reiterated that this hasn't happened before and that she was not hurt. Does not say she didn't feel pain, just that she was not hurt.
Did the officers ask whether she felt pain at the time?
Just have them up here. Jones says that the complaining witness stated that the defendant grabbed a hold of the complainant's hair and pulled it hard, causing her to feel pain. That's as the injury.
It does say that.
It does say that the injuries grabbed a hold and pulled it hard.
Mr. Shape, I'm gonna find that there's sufficient probable cause to go forward with your case. Do we know whether she wants to have contact with him?
Well,
A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up.
the complaining witness is asking to drop charges and to drop whatever bond conditions exist, Your Honor. I don't know if that's.
So what I'm gonna do is I'm gonna order you not to have any threatening or harassing contact with this person. If I find that you do, I will revoke your bond and put you in jail. You need to understand that what is threatening or harassing doesn't matter what you think. I could care less what you think. It's what she perceives. Do you understand?
Yes, Your Honor.
And you've got a lawyer. The lawyers will take care of you. I will waive your appearance so you don't have to waste your time coming to court, but stay in touch with them. They'll tell you if and when you have to come back to court.
Thank you, Your Honor.
Do you mind filing no threatening or harassing conduct?
Yes, Your Honor.
And we can amend the MOA for you as well to take off the residential restriction.
Thank you, Judge.
All right, sir. So what I'll have you do is we'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We're going to get bond conditions created for you. Once you sign them, after that, you'll be free to go. Do not leave until you sign the bond conditions though, sir.
Thank you.
Okay, thank you.
Thank you, Judge.
Okay, hi, Corey.
Good morning, Judge.
What's up?
We got Mr. Reyes. Adam.
Your case?
Yes.
Can I bring him?
Mr. Reyes, come around.
Good morning, Mr. Reyes. Morning. Sir, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, a law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of South Highway 6, turning left. The law enforcement officer turning left at a high rate of speed. The law enforcement officer made a U-turn at the intersection to follow both motor vehicles having to travel approximately 66 miles an hour in a 40-mile-an-hour zone. Law enforcement officer observed the motor vehicles to be side by side with the Honda flashing emergency lights. Law enforcement officers observed the Honda turn off its lights, and both motor vehicles began to speed up again while driving side by side and run a red light. Law enforcement officer attempted to catch up to both motor vehicles, causing the law enforcement officer to travel approximately 90 miles an hour in a 40-mile-an-hour zone. The law enforcement officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. A traffic stop was initiated and the law enforcement officer made contact with the driver. The defendant stated, when asked about the highway speed, no, I was on my way home with my friend Adam, and Adam was following me home. Co-defendant arrived claiming he was there to check on the welfare of the defendant. Co-defendant stated I was following home, but I broke off because I wanted to get something.
So we do have a co-defendant?
I believe.
You know?
One check.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? He has a license.
Yes, Your Honor. And we do have the co-defendant in this case. Got it.
I'm ordering you as a condition of your bond not to participate in this type of activity anymore. You're not to race, do any street takeovers, donuts, driving maniacally, if I find that you do, I will take your privilege to drive away from you, and then I'm gonna put you in jail. Do you understand?
Sir.
I'm not asking much from you. I just want my streets to be safe.
Eligible, Your Honor.
Okay, you're also not allowed to drive unless you have liability insurance in your name. All those are conditions of your bond. You violate that, it's not gonna go well for you. You understand?
Sir.
Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Roth, and he'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you because you're playing games, likewise, I will revoke your bond. We'll have you sign a reset with Victoria. We'll have you take a seat while we get your bond conditions. You'll sign it, and then you'll be free to go, sir. Thanks. Thanks. Take care.
This one was PHA. We already filed a PC.
Oh, we did?
Just
Okay.
had to hire an attorney.
Got it. Okay. So if we have the bond conditions already in there, then free to go. Okay, all right. Thanks. Please. Okay, Mr. Johnson.
Just good morning. I've got a bond violation on Joe Gray House.
Yes, give me 1 second. Mr. Lester, he's been waiting.
Yes, sir. Good morning.
Hey, who's your client, sir?
My client is Nestor Daniel. I can't pronounce that name. Carrillo, Carrillo. Would you like a case number?
Sure. Maybe it might be easier. What is it?
Case number is 25 52 19 00 10 10.
It's Zeniauskas.
That sounds good to me.
Okay. Do you have proof that he's in ICE?
I can furnish the court proof. I'll provide the court with a denial of his bond. We had the hearing. He was denied. His case has been set, the merits hearing, for May the 6th.
Does that mean that you're trying to get him another hearing for a bond?
Well,
I don't know how it goes over there, so I have no idea.
well, his bond was denied because the court did not have jurisdiction because he was an arriving alien. So he is in the custody of ICE at this point. They are not going to release him. And
do you want us to bench warrant him back here so we can take care of this, or leave him over there for now?
I'm not really sure on the answer to your question, Judge. I think that would primarily depend upon you. Do you want to get him in front of you?
The thing that I don't want to happen is I don't want them to end up deporting him without having taken care of this case first, because then it's a headache for everybody involved. You know, if he wants to come back, he's got the open case, he'll have a warrant. It's a huge headache. So, page 22. You want me to just bench warrant him here so we can take care of it? Mr. Lester?
That would be fine. That would probably be wiser.
Okay. And I don't know, maybe you can reach out to the higher ups with the DA's office here, whether there's, a diversion is available. I don't know. Just reach out to them, and then we'll bench warrant him here, and then I'll give you a heads up when we do get him.
Okay, thank you, Your Honor. Just make sure the court understands that his individual calendar hearing, his merits hearing, is May 6th.
Okay.
Anything further, Your Honor?
Yeah, let me see. Hey, so we're gonna bench warrant, bottom of 22. Do we need to put him on a new date?
Yes, they require at least 2 weeks, so how is the 21st?
How's the 21st of this month? Is that okay with you?
I think that'll work, Your Honor.
Okay. And you still welcome to zoom in if you need to. And if we don't get him, we'll just give you a heads up, and then we'll see where we go from there. Okay?
Very good. And you're giving me a reset to the 21st. Is that correct?
Yes, sir.
Council Paul,
Okay, thank you,
Yes,
Your Honor.
reset to the 21st. Okay?
Thank you, Judge. May I be excused?
Yes, sir. Thanks.
God bless. Have a great day.
You too.
Good morning. Got Joe Greathouse on your docket.
Mr. Greathouse, come up.
Judge, you told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
No, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking.
Well,
The concern was that he was drinking. And
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, it does show to be eligible to.
Did it just become eligible, or when was it eligible? You know what, let's do this. I have a line of people, I've got arraignments. Let me put this off a little bit because this is gonna take a
I
lot
have
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on the license. It's the IC.
And what are the days that he's alleged to be driving?
The second judge, let me double check.
Does he have an interlock as well?
Yes, Judge, yes, interlock, he was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a layperson who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with his license. There was no ALR suspension ever. The state told you that. That's why you.
There was a suspension
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order, Mr. Jurisich? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
We
you.
have suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
12/6/2024, end
Pereira?
date 6/3/2025, and the lift date comes in at.
And then if that,
Not saying you're wrong, what I'm saying is based on what I can see is what.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court order.
I understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm gonna throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not gonna put you in jail now, but I want to make sure that you're not drinking. So, does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand? Sir. All right. Good luck, sir. Good luck with your appointment, Mr. Judge. Counsel,
Judge, just to be clear, is he permitted to drive now?
as long as he has the interlock, he's got a valid license and he has insurance, yes.
Does the affidavit need to be?
Yeah, we'll rescind it. Don't. The worst possible thing you could do now is drink. If you drink, you're gonna freaking lose it. Do you understand? Or put anything in your body that has alcohol in it. Don't. All right.
So yeah, real quick, that one was kind of a mess. I get where somebody is going to be confused because like pre-trial tells them one thing, but the judge tells them something different if you don't know better. And, you know, you look at pre-trial and think, well, they're officers of the court. So let me know if you feel, how you feel about this in the chat. I can understand where the guy could get messed up with it, but I also understand the judge's point that he made a ruling, he made a court order, and he expects people to follow it. But this sounds more like a pre-trial problem in a way. I don't know. Let me know your thoughts in the comments. Also, I think I'm going to ride with Judge Fleischer for a little while because he's got a line going. So unless there's objection, we're just going to stick here for a bit.
By those, I'm gonna be happy. The only other thing I'm gonna say, you now have 2 open cases. You pick up a 3rd case, it's really not gonna go well for you. You understand?
Yes, sir.
Keep my community safe. Otherwise, I'm gonna violate the bond. Do you understand?
Yes, sir.
Okay, they're gonna follow conditions. He needs to stay to sign it and then he can go. Do you want the same day as a felony?
Next day, we got it, already put in already.
Perfect. Okay, thanks. Hi. Yes, ma'am. Good morning.
I have Mr. Arroyo on your in-custody docket.
Okay.
We're here for a bail order.
And for what it's worth, you don't really have to approach. The only time is if you need something, then just for, you know, it's a high bond, huh?
It is, Your Honor. We are requesting the PR.
Say it again.
We are requesting the PR bond, so.
In that case, I'm gonna,
I'm so sorry?
I'm gonna need, do you need an interpreter? Sean. You need an interpreter?
No, sir.
Sean, talk to me while we're waiting. While we're waiting, talk to me.
Me and Chief wanted to be able to talk to you about it. Okay, so whatever you got to say.
I guess let me, yeah. Okay, see, you want to talk?
Yes. How's it going?
Trying to be efficient.
I have Allison Dennis today. This was one where I had submitted a PTI appeal back at the beginning of March. You asked me to follow up on it. I
Anything?
did. I got an out of office email from Ashley Geis. So
How long is Judge Geis gone, do you know?
I believe she is back today, Your Honor.
Is it a week?
okay.
Yeah.
Can we wait for appearance again?
Yeah, if it's granted or denied, she's got to be here. Have you done the TRAS yet? No?
No, we've been waiting
So
to
that's why-
see. I mean, I can schedule one and then cancel it if, okay.
Just do a walkthrough next week if she's
Okay.
granted. Just bring her here, we'll do it. If she's denied, also come here, we can take care of it.
Okay.
Okay? If it's no answer, then we'll wait.
Okay, perfect. Thank you, Judge.
Joe?
Judge, I'm gonna let, Jose, go ahead.
Hi, Judge. Oh, no, I need more time. I got to get a record. Okay. So Ramona, can you get ready, please?
Yes, Judge. Well, I can come out in the courtroom.
It's up to you, however you want to do it.
Okay.
Okay, you ready? All right. Good morning, Mr. Arroyo. How's jail? Fun?
I'll say.
So February, you have a terroristic threat with us of a family or household member, and now you've picked up an evading arrest in a motor vehicle. While you're on bond for this case, you pick up a serious 3rd-degree felony. What happened in the terroristic threat?
There's a threat, Your Honor?
The terroristic threat in our case, please.
In our case, on February 3rd, 2025, an officer responded to a weapons disturbance at a residence in Harrison County, Texas. The officer met with the witness who stated that her granddaughter's boyfriend, the defendant, was upstairs in the house with a gun. The witness stated there were 5 other people in the residence and everyone exited the residence safely except for the defendant. Officer met with the witness who stated she had been dating the defendant for 3 years and broken up with him hours before, and the defendant left the residence. When it was asked the defendant if he wanted to retrieve some items, and the defendant said no. The defendant came back to the residence and the complaining witness refused to let him in. Short time later, the defendant sent the complaining witness a picture of him inside her vehicle pointing a handgun at her bedroom window. The complaining witness saw a laser through her bedroom window, which she knew was attached to a handgun that he owned. The defendant threatened to kick her door down and make forced entry into her home. The complaining witness still refused, and the defendant began hitting the windows around the house and screaming the complaining witness's name. The complaining witness called 911 and went inside a different bedroom.
Something out of a movie, like a horror movie.
A second witness, the uncle, led the defendant inside the residence because he was unaware of the break-in. The defendant went straight into his room. The officers tried to make contact with the defendant but were unsuccessful. The defendant was identified by a photo and date of birth.
So tell me what happened now in the new, please, in the evading.
Yes, Your Honor. On April 2nd, 2025, a law enforcement officer was dispatched to a vehicle in reference to a discharge of a firearm. While searching the neighborhood, the law enforcement officer made contact with the witness who advised that the driver was a Hispanic male with light bushy hair, and the vehicle had a plastic wrapping around the rear window with one laminated tail lamp. The law enforcement officer continued to search the neighborhood and observed a vehicle that matched the description. The law enforcement officer made a U-turn and pursued the vehicle. As the law enforcement officer approached the vehicle, the driver accelerated speed and disregarded a stop sign.
Tell me they found a gun.
The law enforcement officer do not have that, Your Honor. The law enforcement officer initiated lights and sirens to stop the vehicle, failed to stop, accelerated speed and disregarded multiple stop signs for approximately 3 minutes and around 1.5 miles of roadway, reaching a speed of 62 miles an hour. There were multiple areas the defendant could safely stop, and the defendant stated he evaded because he believes he had an open warrant for family violence. I
Was this
believe
in warrant status? Do we know?
this wasn't warrant status, Your Honor.
It was a 2B, Your Honor. It wasn't, it was a 2B that was filed. It wasn't so I think they're speaking about the terroristic threat family violence in our case. And it was filed as a 2B. He never was arrested on it or didn't have a court record.
You know, Mr. Arroyo, you need to think that in this world, when you go to jail, you now know you have no one that's going to pony up money to get you out. So when you go to jail on charges, you are stuck unless someone's right. Since January, you've had an unlawful restraint, an assault of a family member. Now you have these 2 open cases. Why would we continue to give PR bonds?
If I may, Your Honor, the 2 previous cases, the unlawful restraint and the assault family member, the file date was back in 2023. He had it set for a jury trial and it was dismissed. He never bond forfeited.
You represent him on this case?
I did not. I was just appointed today to him. But I'm just looking at the procedural posture of the case. He does not appear to be a flight risk of any kind. He took those cases and.
Well, I mean, he's evading capture now with the police, you know? Something's going on with you, man. I don't know what's going on, but who do you have in your life? Who's around to give our mom, dad? Who do you have? You got a son? What? You're a baby yourself. How the hell? I mean, do you live with mom?
I live with my mom.
Well, that's what I'm asking. Who do you live with?
I live with my mom.
Do you actually live there or are you out on the street all the time?
I actually do live there. I stay there and I take my sisters to school in the morning and pick them up after school. And I work and I take care of my son every day that I can when I'm not working. And he sleeps over if I'm not going to work the next day. That's all I'm really doing. But
In the
I
last
just-
couple months, you've had 4 charges. What do we need to do to ensure you don't pick up a 5th?
He is now living with his mother. It sounds like before he was staying with the complainant. So the change in location is going to be helpful, certainly. He now has employment. He works at Cosmic Air.
Let's do this. If you can, is mom here? No.
I don't believe
No,
so.
So let's do this. If you can verify that she will actually take him, because I'm not giving you a PR bond or even a bond reduction for you to just go out on the street. If I let you out, I'm putting you under very strict rules. No dope, no alcohol, and I'm going to test you like crazy. Does he have a license? You're not allowed to drive. I don't care what you got to do. I don't care about your little brother having to go somewhere or your son. If you don't have a license and you don't have car insurance, then no driving. That is a bond condition. I'm going to have you sign an affidavit promising me. If I find that you do, I can have a contempt hearing an additional 6 months. But I'm not letting you out unless you have a stable place to go to, because I don't want you out on the street. Nothing good. And I'm giving you a curfew as well. You understand?
Sir.
I'm going to put a monitor so I know where you are at all times, and then we'll talk. But first things first, not to the street. If you can verify that he's got a place, then let's talk, and I'm happy to do something.
Thank you very much.
Yes, ma'am. Yes. Okay. Joe. That way. Guys.
Thank you,
come on.
Judge.
Put your hands on your side. Hi.
My judge here.
Dan, great to see you. What's new?
Judge, this is a plea. It was a felony case. We refiled it as a misdemeanor.
Okay.
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case
says-
is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of
To
unfair to
see
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can you
Can we-
stand down for a bit?
I'm sorry?
Can you
Just,
stand down to see if she's available to
she
Zoom?
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No, can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, ending on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
Sean, Blaze, you talk to me real quick.
All right, well, Judge Fleischer steps out. Let's go say good morning to Judge Boyd.
He attained competency in August in a jail-based program where they were giving him injections. Since he's been out, he hasn't had one, and I'm concerned for his competency right now.
Okay.
I've discussed with probation options. I do think that if we can get him stable, that we have a plan. But so I'd like to reset today. I'm gonna file a motion today so we can get him evaluated as quick as possible.
All right.
And I don't know if there's a way, I don't even know if you have any power over what they do at the jail, but I don't believe he's been evaluated and he needs his meds because it would help him.
All right. Just one moment. Let me ask you this. Are you refusing to take meds?
No, ma'am.
So they just haven't given you any?
Yes, and I haven't applied somebody to sign the sick calls for me because I have problems.
All right, so has anybody let them know that you're on medication or no?
No.
Have they?
Read judge, so he has a hard time with the forms and things because he doesn't always know unless they explain to him. He's a little. But he was on injections before, and I believe the reason for that was compliance. So they do have those. I'm hoping we can get him back on that.
So here's the thing. If you're not able to read or write, we're gonna have to change that and make sure you're able to read. And there's no shame in that because believe it or not, when I was first born, I couldn't read. Everybody has to learn. We should all look at what our weaknesses are and try to improve on that. And reading is so great. That's why I have books outside the office for people if they want to read. And do not be ashamed if you're starting off with Jack and Jill, because guess what? Everybody started off with Jack and Jill. Everybody started off with See Spot Run, all of that. So there's no shame in that because you're learning. And everyone has their own path and their own journey. I don't know what happened in your life and why you're at this stage in your life, but you're not able to read or write. But we recognize that. So we need to improve that, okay? So whenever you're at the jail, if somebody's handing you paper, because I know sometimes people want to treat this as a factory where we just have to keep it moving. I don't like doing that. So when you're at the jail, if somebody's, handing you papers to sign, you need to tell them, I'm sorry. You're going to have to read it to me because I can't read. So don't just be over there signing your life away. And when you get over there, you need to let the nurse know that you need to be on medication. And whatever your diagnosis is, or you believe your diagnosis to be, you need to let them know because they really should be pulling records over there. You understand? So do you have any objections to me contacting the sheriff? All right.
I think it might be very helpful.
All right. So just give me one moment. Let me do this now. Otherwise.
All right. Well, since she's muted herself, let's go to Judge McNally's court, see what's going on over there.
Dinsky. I did call that, right?
We're waiting for counsel who's doing another case.
I see. I'm sorry. I'm sorry.
I'm here, guys. I'm here. Gary Amps, I'm here.
Capital One versus Anthony J. Brzezinski, 2404940. Okay, everybody's name?
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of Capital One.
All right. Do you guys want me to just give you, Mr. Amps, by the way, what is your P number, sir?
046306.
So it's 46306, right?
Well, all the notices I get to appear have the 0 in front of them now, so whatever.
Yeah, I get it. All right.
Okay. I believe they're making room when we cross 100,000, whenever that happens.
Oh, is that?
He's doing civil stuff, which isn't overly engaging. Let's go back to Judge Fleischer. He's back on the bench.
Oh, outside. Ramona, tell me when you're ready.
Ready, Judge.
All right, we are on the record in cause number 251-8785. This was a motion to suppress, a dispositive motion to suppress that we had. I'm going to grant your motion. We had reset this case. If I'm not mistaken, we had reset the case several times because of the availability of the officers, right? I mean, just to be nice, right? And then we have this motion to suppress. They get here and it's like, they didn't even look at it. And it was just, it's something I've never really dealt with like that. And so I found that I didn't find any credibility with the testimony. So I'm going to grant your motion. Right. So off the record, I think that this is a great teaching moment where you should never assume officers are prepared. You know, when you first go to them and when you're preparing for trial, you ask them and say, hey, have you read over this? Are you familiar with it? Are you ready? You never assume. I mean, that was just 101. So for what it's worth, you know.
All right. Thank you,
Okay.
Judge. Yeah, sure.
It is what it is.
All right.
And then I am sorry it took so long.
No, it's okay,
So
Judge.
just get your client, I don't know if your client has anything like any interlocks
He has an
or,
interlock.
so just have him come back and then we can take everything off.
Okay.
You know, once we enter in the order and it shows dismissed, he'll be able to go to the, I think it's pre-trial and they'll be able to take it off.
All right. Thank you, Your Honor.
Okay, well, there's the update to what we witnessed on the live show last week. If you'll recall, we had that motion to suppress hearing where at the end what was going to happen was if the prosecution won that hearing, they were going to proceed immediately to a pre-negotiated plea. If the defense won that hearing, the case was going to be dismissed. And at the end, the judge was really frustrated with the quality of the witnesses. He said he would get a ruling in a couple of hours. We never heard that ruling, but I went back and found that the files had been sealed, which implied to me that this case was going to be dismissed. Well, there it is official now. That case was dismissed. So we heard it live. We know how that happened. If you're not familiar with what I'm talking about, go to the Courtroom Files YouTube channel page, and there's a relatively recent video there that I pulled out of the live where we show the entire hearing, and then at the end I point out that the records had been sealed, and here's what that implies to me. But now it's official. We know what happened. Judge left the bench yet again. So I'm probably going to go back to Judge McNally based on what's going on. But let's talk about one more thing real quick. I had a back and forth with somebody in the comments. Excuse me. Had a back and forth with somebody in the comments this weekend about being on the record. And it had to do with that hearing, because I pointed out at the beginning of the hearing how odd it is for a judge to officially go on the record. It doesn't often happen in his court. And this person was insistent that everything is quote unquote on the record. His live stream is not an official record of the court. What happens when they put something on the record, that's when Ramona, his court reporter, comes out and they make an actual word-for-word transcript of what happens. It's not the same thing. And most judges don't run their entire court on the record. There's not a word-for-word transcript of everything that happens. If you want another example, that listen to Judge Boyd's court, and she's constantly saying on the record, off the record, because she only wants official things to be transcribed, not the back and forth, the things that could be handled through paperwork, stuff like that. So it's not the same thing. What we're watching is cool, but it doesn't serve as an official record of the court. Anyways, just so people are clear on that. Well, looks like Judge Fleischer's back on the bench now, so let's actually go back there and see if he's still working through people.
Deferred.
Or not. He is so unpredictable lately. McNally.
So, Mr. Lateef, do you understand me, sir?
Yes.
So are you telling me that you do not owe the 906.84?
Yes, sir.
All right. Okay. Ms. Francis, let me do this. Do you want to try to talk to him in a breakout room, and maybe you two can figure out what the dispute here is?
Judge, I think just a scheduling order would be good in this situation, and we'll file a motion for a summary.
All right. All right. Let me make a note here. All right, so I'm going to go ahead and give you until June the 1st to conduct discovery. May 1 witness lists are due. I'm going to set a trial date. Nobody demanded a jury trial. There will be no settlement conference because of that. You don't have to file a trial brief. If you want to, you have to file, exchange it not later than 7 days before the trial. I'm going to put a trial date on this scheduling order. Mr. Latif, I'm going to encourage you to call them. Somebody's making a mistake in math, probably. Maybe it has to do with interest. Maybe it doesn't. But maybe you two can talk and try and resolve it at some point. It's $906. So
Can I speak?
no,
Because
you
I feel-
can't. You can't. You
Your
can't.
Honor, I pay already $4,900, $91 to the Goodyear. I don't know how they charge me $900 again one more time because I do deal with $4,900. I pay already $4,900,
Maybe
$91.
hang on.
And
Hang
they
on.
charge
Maybe
me $900 more.
hang on. Time out.
Okay.
Maybe it's a mistake in math. Why, one or both of you? Who knows? It just seems like this is small enough where the two of you should be able to put together numbers and try to resolve it. I don't know who owes who what, but I'm going to set a trial date. I'm going to let you guys figure it out. If you can't, well, we'll just go to trial. What's the trial date, Lisa? Linda, geez.
You can just call me Lisa.
I think
did you want that? Did you want that in June or July?
That's perfect. June.
Okay, June 17th at 10 o'clock.
June 17th at 10 will be your court date, okay? So you can come here then. I'm hoping you two can talk in the meantime and try to resolve it. If $1, you should be able to figure it out. Okay? Any questions, Mr. Latif? No, I don't want you conferring with her. You can't do that. You can understand me. She can't be your lawyer or representative here or anything else.
So how we
Do you have a
solve
question? I didn't hear what you said.
I said how we solve this problem?
We're going to go to trial unless you and Ms. Francis or somebody else from that office resolve it.
Okay.
I mean, I don't know. I can't just take her word that you owe 906, and I can't just take your word that you don't owe 906.
Yeah.
So I'm going to decide. Okay?
Okay.
All right. Good enough. Good luck. Thank you.
Thank you, Judge.
I have Thank you very much, Ms. Francis.
Thank you.
Good luck, sir. Thank you.
Thank you.
Do I have performance equity versus Fry?
All right, let's switch gears. Let's go to Tennessee. Stewart County is where he is today. One of my personal favorite judges, Judge Wolf. So let's say good morning to him.
All right, I have what is installed a second amended motion for new trial that was filed on November the 12th of 2024. And then we have a second amended motion for new trial, the memorandum of law that was filed February the 28th of 2025. I'm not sure if there's any substantial difference between those two, but is there a particular difference that I need to address in the motion, or is it one's the motion plus the memorandum?
No, Your Honor, I think it's.
You're gonna need to probably just come to the podium if you will.
William Silver, on behalf of Mr. Powell. It's the motion that's one filed in February, late February, is primarily the same, some additional argument, a couple of additional cases referenced, essential.
Any new issues that are argued, just more argument and authority?
I think the issue regarding the additional issue is there's a reference to violation of a motion in limine that was added as an issue grounds related to statements about the conviction of Mr. Jason Perry. It was more specified. Other than that, I think it's substantially the same.
All right, well, I'll hear your argument.
And John, before we get started on that, I would ask that that we incorporate the first motion for new trial issues raised. And I won't spend a lot of detail in the argument today, but incorporate that for the record as part of the whole motion.
We'll show that we're going to be hearing both the original motion for new trial as well as the second amended.
Yes.
I'll pull that up, but go ahead.
Yes, Your Honor. Based upon Tennessee Rules of Criminal Procedure 33, we move the court to grant Mr. Abdullah Powell a new trial on the grounds initially that the evidence presented was not sufficient to support the convictions. And of course, in this case, Mr. Powell was convicted of counts 2, 3, and 4 of superseding indictment, superseding presentment number 2017 CR 155 on December 2, 2022, after trial by jury in Stewart County Criminal Court. He was acquitted on count 1 of the indictment. The count 2 was for the criminal charge of first degree felony murder during the commission or perpetration of a burglary in violation of TCA 39-13-202. He was convicted of in count 3 of first degree felony murder during the commission of theft or attempt to commit a theft in violation of TCA 39-13-202. He was also convicted in count 4 of the presentment of aggravated burglary regarding alleged or burglary that occurred at a different residence on a different date involving Ms. Wanda Gillett. So the evidence presented at trial was not sufficient to support the convictions. And according to the State versus Cabbage, the trier of fact must resolve all questions concerning the credibility of witnesses, the weight of the evidence, the factual issues raised by the evidence, and the court has the ability to do that essentially on a motion for new trial as a 13th juror. The motion for new trial based upon the verdict being against the manifest weight of the evidence may be granted when the government has presented sufficient evidence to convict, but the trial court judge disagrees with the jury's resolution of the conflicting evidence. And that's from Tibbs versus Florida, 457 U.S. and 31, page 42, of that opinion. In this case, what I want to do, Your Honor, is go through, essentially, I'm not going to recite everything that occurred during the trial, but just try to summarize some of the main points or arguments here. And essentially, with regard to the evidence in count 2 of felony conviction, felony murder based upon the underlying offense of burglary, there was no evidence that put Mr. Powell in the position or in the residence where the event occurred, where the death occurred, or to say that he was committed or had the specific intent to commit a burglary at that residence. And I look, of course, at the statute. One of the issues with the statute that of burglary, one prong of that is that a person commits burglary who, without the effective consent of the property owner, enters a building other than a habitation or any portion of that building not open to the public with the intent to commit a felony theft or assault. The testimony at trial by Detective Atkins was there was no sign of forced entry into the residence. So there's no evidence during the trial that Mr. Powell entered without the consent of Mr. Cooks. There's no one that testified to any of those facts. There's no testimony that he was actually there's no physical evidence that he was even at the premises. There's no fingerprints, no DNA evidence taken from that particular residence, which is a double wide trailer, I believe, with the front porch, wooden front porch. But there was no evidence that it was broken into, according to Detective Atkins. And there's no evidence that there was that Mr. Powell had an intent, that he entered and that he had an intent to commit a felony theft or assault. And likewise with the count 3 of the indictment, based upon the underlying felony theft, there was no evidence presented that anything was taken. There was nothing stolen or no evidence that presented that state or showed that there was anything taken from Mr. Cooksey's residence, nor was there anything found in the possession of Mr. Powell that came from that residence. There's no testimony about him being there on that particular night. There was testimony from Mr. J.C. Perry that on some night in 2016, I think he said in the summer of 2016, that he picked up Mr. Powell and some other individuals, and they drove to Cumberland City, and later that night they went back to Clarksville altogether. But he did not specifically state any date. He didn't say where they went. So that would be insufficient to show that he was at the residence on that night that Mr. Cooksey was killed. The testimony regarding Mr. Powell's involvement or alleged involvement in these crimes primarily come from Ms. Amy Hankins, a co-defendant, one accused in the same criminal activity, a person that also received a plea agreement from the state. Based upon that, her testimony is not reliable and is subject to higher level of scrutiny. In this particular case, we still operate under the common law principle that her testimony as a participant, as a co-defendant, should be corroborated. Tennessee accomplice corroboration rule is justified by the theory that accomplice testimony is unique and must be considered with a different degree of scrutiny than other testimony. Because accomplices also often have an incentive to shape their testimony in a manner that would help them curry favor with the prosecution and the police. And because of an accomplice's status as a guilty party with inside knowledge of the situation, they can make the jury more susceptible to believe their testimony. Proponents of accomplice corroboration rules see such rules as a necessary safeguard criminal defendants. I should point out, of course, that that common law theory has been overturned by the Supreme Court of Tennessee. However, not only prospectively and not retrospectively. So in this particular case, it was still applied, and the court would have to look at whether or not the testimony of J.C. Perry and Miss Amy Hankins were sufficiently corroborated by some other evidence in this case. And as we look at this case, and as I've already mentioned, there's no physical evidence that puts Mr. Powell in the residence of Mr. Cookson. There's no physical evidence that says he was there that evening. And as far as the Ms. Gillum's residence a few days prior to the incident at Mr. Cookson's residence, Ms. Gillum is the only witness to that particular event. She stated on the stand that she woke up in the night, person had come in through her bathroom window and was fully covered in black, wearing a black scarf around the person's face. So she could not identify anyone that came into her residence. However, there was she stated a black scarf that the person was wearing was left behind. So as we evaluate and look at the evidence that was presented, two things about that incident that are very important for analysis here. One, the severance, the motion to sever the two offenses, because they occurred on different dates, there were different victims, and the defense had moved to have those offenses severed. The court denied the motion to sever, specifically citing the basis that it was based upon a common scheme and plan, or that the evidence could be presented as a common scheme or plan, which would make it relevant into the defense with Mr. Cookson. With that being said, there's nothing specific about or specific about that type of burglary that would make it unique. In fact, it's a standard type of breaking at night. There's nothing specific about the way it was done, or any type of method that was used that was different than any other burglary. And obviously, it's the only way that the state was able to try to link Mr. Powell to the offense or the killing of Mr. Cooksey, based upon the fact that the scarf that was collected at that scene was later analyzed by the Tennessee Laboratory DNA lab, subsequently sent to cybergenetics to analyze data that the state collected in the form of DNA skin cell analysis for DNA. And that brings up the next point, which is that we believe that the cybergenetics analysis should not have been admitted into trial. The test should not have been admitted at trial. We believe it to be unreliable evidence. We believe that it was unduly prejudicial in the sense that without substantial information to explain the importance of the type of analysis that was done, the jury could easily be misled. Specifically, it was tested. The type of DNA samples that was pulled from the scarf were touch skin cells. Skin cells, such as when you rub your face or you touch something and those cells are transferred to the item. So that's different from a type of DNA that would come from, say, blood or saliva that would have much more DNA evidence in it. And it's much more easily traced to an individual. The skin cells, as it was testified to during the trial, are residue, and as such can be transferred and easily transferred. So it is important to note that just because, even if Mr. Powell's DNA was on the scarf, doesn't mean that he was present in Ms. Gillum's home. It doesn't mean that he was the person that had the scarf on. It's no doubt, and there's been no denial that Mr. Perry was friends with Mr. Lovelace, that they knew each other. Amy Hankins testified that Mr. Lovelace was her boyfriend at the time. Mr. Powell was dating Miss Amy Hankins' sister, Ashley Hankins. It is quite possible and conceivable that DNA from innocently could have been transferred to the scar along with others, because one of the reasons why the state lab, the Tennessee TBI lab, could not identify anybody from the DNA samples on their own was because there were numerous samples on that one item. So they could not differentiate. They couldn't distinguish one person from another. So they sent it to cybergenetics. Cybergenetics did not actually run any DNA evidence. They didn't run any tests on it. They used a computer to try to separate out the DNA makeup to try to identify whether it belonged to one person or another that from which they had known samples. So looking at all of those three things in a whole, the evidence is insufficient to put Mr. Powell in the presence of Donna Cooksy's home and or Miss Wanda Gillum's home. Next, I wanted to bring up the fact that the defense had filed a motion to change the venue on several occasions. That motion was based upon the fact that there had already been at least 2 trials of this matter prior to Mr. Powell being sitting for trial. There have been numerous articles in the paper. There was so much publicity in the town is relatively small. The jury pool knew very well what this case was about and had heard lots of information about people being convicted prior to the trial. So it was court so the defendant renews the motion to the extent that the court would consider as part of this motion, this post-trial motion, the prior motions to change venue and reconsider that in light of the fact that it was impossible for Mr. Powell to get a fair and impartial jury based upon the venue. One of the things that occurred during the trial next was the cell phone tower location testimony from Mr. Sean Atkins. Detective Atkins testified as a rebuttal witness for the state. So Mr. Perry had testified during the state's case in chief. And during his testimony, as I mentioned earlier, he merely stated that he had picked up Mr. Powell. They rode together to Cumberland City, somewhere in Cumberland City, and they drove back to Clarksville. He never mentioned anything about Mr. Cooksey. He never mentioned anything about Miss Gillum 2 nights prior. He didn't mention anything about any criminal activity, right? But the state did not bring in a witness during their case in chief to discuss the cell tower information. They called in Detective Atkins as a rebuttal witness and used not the cell phone records of Mr. Powell, but the cell phone records of Mr. Perry to testify to try to pinpoint the date and to make opinion testimony, to offer opinion testimony about the location of Mr. Perry on the date in question, on the date of when Mr. Cooksey was killed. So these records were not related to Mr. Powell. They were related to a different witness, Mr. Perry. And they came in as a rebuttal. And that's improper rebuttal because the state is rebutting their own evidence, not rebutting anything that the defense put in. Because at that point, the defense had rested, but only called one witness, was Mr. Eric Cookson. Next, we wanted to point out that during the closing arguments, the defense objected to state vouching for the credibility of their witnesses during closing. During the closing, the assistant district attorney characterized the testimony of John Perry as saying, "I would submit to you that Mr. Perry has absolutely nothing to gain from coming in here and lying." I ask you to consider these facts. Mr. Perry is serving a life sentence at TDOC. Mr. Perry's appeals have been denied. I ask you, what does Mr. Perry have to gain from coming in here and lying? For her pre-trial motions, in this case on November 5th, 21, at the conclusion of which the parties announced that they agreed to the defendant's motion in limine, that there were statements by the other three co-defendants would be not allowed to be in. I'm sorry, co-defendant testimony were not allowed to be in. Also, that there would not be introduced to the jury that the other three defendants had gone to trial and were convicted. So in this situation, the state vouched for the credibility of one of the witnesses and also, in essence, violated the motion in limine, which had been agreed upon, that there was not going to be any mention about any of the prior trials ending in a conviction in this case. So we believe that is also a basis and ground for because the court did not give a limiting instruction or declare a mistrial. So based upon that, we believe that Mr. Powell was prejudiced by the jury.
Are you saying that there was a contemporaneous objection to that argument?
In my review, there was an objection during the closing argument.
To that particular point?
To that point, I did not hear him ask for a mistrial. I did hear him ask for make an objection, which I believe was sustained. With regard to the last point, Your Honor, that I want to discuss this morning, the court, during the trial, Mr. Powell asked for a new counsel. He asked for his counsel to be relieved. And it was, I want to say, on the last day of trial, but before the case had gone to the jury. And it was on December 2nd, during the beginning of the day. And the court summarily denied the motion without a hearing or without asking what the basis of the request was. The court concluded that it was too late for that to go on and that the trial and advised that his current counsel was a good attorney, but the court never asked what the basis for the request was. After the request was denied, based upon the review of the record, it appears that the relationship was between counsel and attorney and client was diminished, and even the presentation of counsel appeared to be not as vigorous. Objectionable testimony came in, that objection. So we wanted to point out that, like any relationship, the attorney-client relationship can be challenging, especially when a person is facing life in prison and on trial. So, of course, we know that the Constitution of the state of Tennessee and the United States guarantees a right to counsel. And that right is the right to effective counsel. And it's at this point not that an issue for that we're saying that we're not raising an ineffective assistance for counsel claim in this particular motion, but rather that the court should have made inquiry into the reasoning for it in order to determine if it was something that was substantial that required relief. And in that, on that grounds, we did ask in our motion, I earlier mentioned there wasn't anything new. This was in the original motion, but I did ask in this motion to be able to make an offer of proof. And I wanted to call Mr. Malik Rashid, my client's father, who's here, who was present, who was part of that conversation that precipitated Mr. Powell asking for a new counsel. I would ask if we would be able to testify about that limited issue before the court to make an offer of proof.
I'll allow you to make your offer of proof if you want to put it on your whatever proof you wish to. Obviously, that may or may not be considered by me because it was certainly not offered at the time of the motion or the request for a different attorney. But I'll allow you to put on whatever offer of proof you wish to do. But you want to do that now?
Yes, sir.
All right, bring your witness up.
Mr. Commissioner. That's good.
So real quick while this witness comes up, I'm going to continue to run with this hearing. There's a lot going on in other courts, but honestly, it's the same stuff we always see where this motion for a new hearing isn't something that we always run across. So I think this is more intriguing. It's something, again, that's a little more unique. So I'm going to stick with it. For clarity, motion for a new trial. I think I said motion for a new hearing. Motion for a new trial.
Malik Rashid. And Mr. Rashid.
I'm sorry, can you spell your name for me?
ABDUL-MALIK.
Thank you.
Last name?
Yes.
RASHEED.
EED?
Yes, ma'am.
Okay, thank you.
And Mr. Rashid, how are you related to Mr. Powell?
My son.
And where do you currently reside?
I live in Texas, Frisco, Texas.
And what do you do there in Texas?
I work for a corporation called L.P. Harris. I work on a project called This Sam. Very important person, special airline mission. What we do, we work on executive aircraft to fly our government, all of our security, the president, vice president, both Air Force One, Air Force Two. I make the lesson plans. That's the class to train the communication system operator on how to operate the equipment we install the system.
Okay. And based on that, I'm assuming you have some military background, is that correct?
I'm retired military, 28 years, also a disabled vet, 100%. Served 3 wars. Served now, I served for golf, also served in Grenada.
Okay. Now, you remember, I'm sure, you remember the trial, your son's trial, is that correct?
Yes, sir.
And were you present for that trial?
Yes, sir.
And did you participate in conversations with his then attorney and Mr. Powell?
Yes, sir. Every time there was a break, we stepped out and had a little conference in the back of the courtroom, opened the corner by the mirror and grip. And I was involved in what was going on.
Now, as I mentioned before we called to the stand, it was by my notes, December 2nd, 2022. During the morning, that morning before the trial, before the jury was called in, do you recall there being your son asking for the new counsel?
Yes, yes, sir.
Do you have information as to what that was about, why that came about?
Yes, sir. The attorney was about to close the case, and he had told us previously that there was a key witness. Am I allowed to say the name of the witness?
This is, you asked your lawyer, not me.
Am I allowed to say the witness's name?
Yes.
His name was Eric Cussy. He told us that Eric Cussy was his key witness, that he could use Eric Cussy to prove that my son was not guilty. Now, he was about to rest the case, and I'm like, where's Mr. Pussy? I asked him this question. He said, well, we subpoenaed Mr. Pussy. He didn't show up. So shouldn't you be telling the judge if you have a key witness that didn't appear and ask for a postponement until you can get that witness? He said, we subpoenaed him twice. He didn't show up. The sheriff served the warrant he's running. Said, you shouldn't be telling us that. You should be telling the judge that. He said, if you want Mr. Pussy, you go find him yourself. He stormed off. Went back and forth. And my son came back in and said, I need not with this. That was the second issue. There were others. That was the main one. Probably the situation.
Okay, and there were other things that led up to it when you say that. Is that what you're saying?
Yeah, there were other things. In the first couple of days of the trial, the prosecutor was presenting evidences about phone records, and he didn't have any documents. He didn't have any hardcore documents. It was he say, she say. And I asked him, said, did you subpoena my son's phone records? And he said, I don't need them. They're lying. I can prove it. Then on the last day of the trial, they used Mr. Perry's record. I said, why didn't you have my son's phone records here? You could get rid of all of them. So those were concerned about it. He wasn't doing the thing that we thought that he should be doing to adequately represent my son.
And during the end of the trial, or around the time when your son had asked for new counsel, did you learn also whether or not Mr. Cooksey had been subpoenaed by?
He had not been subpoenaed. They called him to the stand. He said he was at his job, and they called him in, and he came in voluntarily. The defense the prosecutor asked him, did you come here from a subpoena? Did you come here voluntarily? I came here voluntarily on my own. He said, where were you? He said, I was at my job. And they came and said, we need you for a trial. I left and came.
Yeah, I think this is what I have. Any question for us?
It's your offer of proof. Thank you. You may step down. Do we have any other arguments?
Well, Your Honor, just in conclusion, I would state that the court should grant Mr. Powell a new trial based upon what we've discussed here today and the rest of the details in the brief. And I'd like to make sure that the brief, my memorandum, and what we already discussed, the first motion, be included in the record as part of this hearing.
Cool.
And we'll rely on that memorandum and the remaining part of the arguments made therein, and ask the court to grant Mr. Powell a new trial.
Thank you. I'll hear from the state.
Thank you, Your Honor. I just want to briefly address a few of the issues brought up in the motion. I'm not going to spend a lot of time. Starting under the sufficiency of evidence, I'll remind the court, and the court has heard 3 trials in this case. Specifically in this trial, I will refer to the testimony of Tiffany Miller. And Ms. Miller's testimony is outlined on page 11, the defendant's second amended brief memorandum of law. And I will quote directly from page 11. Ms. Miller testified, quote, she heard a phone conversation with John Perry and Abdullah Powell on speakerphone, where Mr. Powell asked Mr. Perry to give him a ride to rob somebody, which obviously addresses the intent to commit the robbery, which is what the conviction felony murder is based on. Further quoting Ms. Miller's testimony, she clarified that he was talking to Mr. Perry about going to hit a lick. The court can also call from the trial, Mr. Powell testified and was cross-examined about, quote, hitting a lick. Second, on page 12 of the defendant's memorandum, still quoting from Ms. Miller, on redirect examination, Ms. Miller identified the white truck in the surveillance video as John Perry's truck and the passenger in the blue shirt as Abdullah Powell. And here's why that's important. She's already identified the conversation that she hears them discussing going to commit a robbery. She identifies the truck that was driven to Cumberland City from Clarksville, truck being driven and owned by Mr. John Perry. And there's a video from Cumberland City, from just down the block from where the 2 robberies occurred and 1 homicide. In this video from Cumberland City, Ms. Miller is identifying the defendant, in this case, Mr. Powell, as one of the occupants. Second, quoting from the summary of Ms. Hankins' testimony from the defendant's motion, page 12, Ms. Hankins testified, quote, that she and her sister were not at the scene of the crime, but that Abdullah Powell, John Perry, Gerald Lovelace left her house to go commit a robbery. She explained that they had left Abdullah's house that night. So they went to commit a robbery, Your Honor, and they left to commit this robbery from Abdullah Powell's house. JC and Abdullah rode together. She and her kids rode with another person to her house. She stated that the 3 men had left from her residence together in the white truck driven by John Perry. So that's 2 witnesses, quoting from 2 witnesses in the state's proof. Further, on page 13, Ms. Hankins continued to testify that, quote, she saw Gerald and Abdullah with guns. She testified further that the 3 left her house in the white pickup. And more importantly, she testified that there was a previous attempt to rob Mr. Cootsy's house, but they went to the wrong house. So that ties into the robbery of Miss Gilliam's house, which the court heard lots of pretrial testimony about. Why that's important and why it became important at the state's at the trial and the state's evidence is that in the robbery of Miss Gilliam's house, a scarf was found, and that scarf was containing the DNA of the defendant, Mr. Abdullah Powell. So we have testimony from Ms. Hankins that they had already messed up and robbed the wrong house the night before. That's the house of Miss Gilliam. And it was a mistake. They didn't mean to go to that house. And that's one of the reasons that I believe the court relied upon for use of this evidence of the scarf is the mistake. You know, it shows their intent to go to Mr. Cootsy's house, but they went to the wrong one, and a scarf was left behind containing the evidence for the DNA of Mr. Powell. All of these things go to the sufficiency of the evidence. Next, Your Honor, I will move to the cell phone tower location argument in the defendant's motion. Part of the reasoning, part of the proof of the cell phone tower location was to go to rebut and to clarify Mr. Powell's testimony. And he took the stand and essentially his testimony, and I'm paraphrasing, he kind of separated himself as far as his knowledge and friendship and relationship with the co-defendants. But the proof had already been putting them in a truck together, so therefore showing the cell phone tower location data of Mr. Perry's phone when we know Perry and Powell were together was an important piece of rebuttal information. Then the last thing I want to address, actually 2 more things. Under the closing argument issue that the defendant has raised, I want to quote from the defendant's motion. On page 28 of the defendant's motion for trial, the second amendment motion says, in addition, the state violated the order granting defendants motion in limine regarding statements to the jury about any of the co-defendants being convicted of this murder. In closing argument, General Turnbow stated, quote, Mr. Perry, I ask you to consider these facts. Mr. Perry is serving a life sentence at TDOC. Mr. Perry's appeals have been denied. I ask you, what does Mr. Perry have to gain from coming in here and lying? So if the court remembers, a lot of questioning of Ms. Hankins was tried to destroy her credibility, or cross-examination of Ms. Hankins, saying, hey, you should question her credibility because she's been given an offer by the state, therefore, essentially making an argument that the jury can't believe her because she's been given this offer. Well, this is not the argument made by General Turnbow is not in violation of any pretrial orders. He's not talking about the conviction of Mr. Perry per se in this particular case. What he's trying to do is balance the argument of the defense that, hey, anybody who's in here who's a co-defendant testifying to you must be lying to try to get some kind of deal. But that's can't be the case here, because we know J.C. Perry didn't get any kind of a deal. He's serving a life sentence. So while Mr. Turnbow, maybe it's threading a needle a little bit, he still has a right and argument to rebut inferences that have been made by the defense. And that's what happened in that portion of the closing, to the best of my recollection. And finally, I'd like to address the failure to relieve counsel argument that has been raised in the motion for new trial. In turning to page 13 of the defendant's second amended motion for new trial, I think this issue is moot because the defendant actually called Eric Cooksey as a witness. So I know there were requests for subpoenas and subpoenas issued for Eric Cooksey as both. I think the record reflects that the case was continued a couple of times. I'm not sure how many times Eric Cooksey was actually subpoenaed, but nonetheless, that's all moot because the defense called Eric Cooksey as their first witness. So this argument about Mr. Flanagan should have been relieved from counsel because he failed to obtain a witness, that's null and void. I mean, he literally called him as a witness. And that is reflected on page 13 of the defendant's motion where it says, Eric Cooksey, I'm quoting, Eric Cooksey testified as the defendant's first witness. That's all.
You have to be heard, Mr. Stover?
Yes. Failed to mention earlier that in the brief, it was hard to remember exactly the new stuff I added when you asked me that question. One of the things that we did add was a questioning of the scar being the same scar from these pictures from the evidence from the discovery being different from what was presented at trial. My client had reviewed that evidence since the trial, reviewed these pictures for the first time, and disputes that, believes that the actual scar that was at trial is different, a different scar. And to that extent, I wanted to put that on the record. I did in the motion ask for the actual exhibit to be brought in, and I don't know if that is here. But I know it would be in the record, so I would submit in lieu of having it brought out right now. If it's not here, I would like to submit these pictures as part of the record as an exhibit to this testimony, and then it can be reviewed at a later date. With the
You want to mark that exhibit as that photograph as an exhibit to your argument?
Yes, I've got three and like a collective exhibit.
That's fine.
And then lastly, Your Honor, with regard to General Crouch's rebuttal, when it comes to the cell phone records, Mr. Detective Atkins testified as a rebuttal witness before Mr. Powell ever testified. Right? So it cannot be accurate that the reason for that is Mr. Powell's testimony. Mr. Powell, if you were called to testify, was called as a rebuttal witness. The only witness that the defense called in this case in chief was Eric Cooksey, and who wasn't under subpoena, but who had been located, I believe, by the state's assistance, and they brought him in and got him here. But just to clarify the record, for my review, Mr. Powell did not testify until the very end. It's a surrebuttal after Detective Atkins testified about the cell tower location. And part of that reason that he felt compelled to testify was because of that testimony. That's all. That's renewed the motion.
You may.
I think Mr. Stover is correct. I'm not disagreeing with that. I remember, may not have correctly recalled the order in which Mr. Powell testified, but I believe he was a served rebuttal witness. So my argument about being called, seldom proof being called to rebut Mr. Powell is incorrect to that point, but it was called to rebut the cross-examination of other witnesses and putting the two together.
All right, well, this was the third trial of a third trial that took place as a result of this particular situation. There were 5 defendants originally, Amy and Ashley Hankins, and then Mr. Perry, Mr. Lovelace, and Mr. Powell. And the court is well aware of the fact that the first 2 trials that took place raised many of the same issues on our pretrial motions that have been raised in this case. And in those instances, on their motions for new trial, those issues were considered and overruled, and the Court of Criminal Appeals has affirmed both of those prior convictions that occurred in those cases. So obviously, I'll need to refer to those decisions regarding the issues that were raised that were similar or the same that were issues that were raised here. One of the issues that the defendant hears, and I'm not going to address every issue, I'll need to make a written ruling on all of this, which means I'll have to take it under advisement to make that final ruling. But one of the things that has been raised has been the insufficiency of the evidence to support the convictions. And frankly, I found that the result of the trial, and I find today that there is sufficient evidence that corroborates the co-defendant's testimony. While there is no evidence of a forced entry, that doesn't mean that the effort of these parties wasn't with the intent to enter into his home. Or as we know, he may not have locked his door that night in particular. But in any event, the fact that there was nothing stolen from the victim is, again, that's an issue for the jury to consider whether or not there was or was not sufficient evidence. But what I do find was compelling was that there was security video that the jury was able to see and to observe of this vehicle, a white truck being driven in with the 3 occupants, and the hood of the truck was lifted, and there were things that were obtained from underneath that vehicle. That corroborated the testimony of Ms. Hankins, who testified at length about how the process in which if they were going to go, I've forgotten the term she used, but basically they were talking about carrying a weapon, and they would put it under the hood of the car on the breather to avoid being stopped and taken into custody because of a gun. So that was consistent with what was observed by the jury on the video. And as was testified, Ms. Miller and Ms. Hankins both testified as to specific things that were corroborated by the evidence of that video in the vehicle, the individuals, and so forth. And Ms. Miller specifically identified the defendant in this case as being one of the men in that truck that night. So I found that there was sufficient evidence, and I'll supplement that with my written ruling, but I do not find that there was insufficient evidence to support a finding. As to the motion to sever offenses, I did deny that in a pretrial hearing. The reason that I denied it was because of the very fact that the evidence was pretty compelling from Ms. Hankins, if none other. Ms. Hankins testified that there was an effort to steal drugs and money from Donald Cooksey at his home, and that they had given this information to the defendants, Mr. Powell being involved in that, and they went to the wrong home. They went to Ms. Gillian's home, and Ms. Hankins even made some derisive statements about the fact that she couldn't believe that they went to the wrong place and she was going to have to show them the right place or something on that order. but it clearly was consistent with what took place from Ms. Gilliam's testimony, the DNA evidence off of the scarf. We had a pretrial hearing in which this court considered both the state and the defendant's argument about the introduction of that evidence. I ruled that, and as a result of the pretrial hearing, that the evidence was sufficiently scientific enough to be allowed to be introduced. And like any other testimony of an expert witness, it would be considered by the jury and given such weight as they deemed to be appropriate. Interestingly, I think if I recall correctly, subsequent to my ruling in that case about the introduction of that evidence, the Court of Criminal Appeals considered the very same evidence in a non-related case and found that that evidence was in fact scientifically accurate enough to be introduced in the appropriate case. So I think there's already a Court of Appeals decision that would affirm or would agree with my ruling in the case on the DNA evidence. The motion to change venue, number one, there was a motion to change venue, and this court did consider that, but it was withdrawn by the defendant, if I recall correctly. But in any event, the jury selection process took place, and not one person that was selected for jury service in this case had ever heard anything about this case or had any prior knowledge about this case from having read or heard anything about it. Both sides were given an opportunity to question the jurors at length regarding any knowledge that they might have that would weigh on their ability to be fair and impartial. Not a single witness that was later chosen for the jury in this case had ever heard anything about that. And as a result, this court is of the opinion that there was no proof given that a change of venue would have been required in this particular case. As we both know, you can't just say, I want to change a venue. You have to demonstrate that there is a need for a change of venue. And as we proceeded, I believe, if I recall correctly, I indicated that if we got into the jury service and jury selection and could not find a jury that was free of any sort of pretrial publicity, then we would consider moving the trial to Charlotte, Tennessee. But we just simply didn't have that problem because none of the jurors had ever heard or read anything about it. Several years had gone by since the last trial, I think, prior to Mr. Powell's anyway, involving this case. Lastly, on the defendant's request to dismiss the attorney, I would simply point out that Mr. Powell had prior attorneys. He had retained Mr. Flanagan as his attorney prior to trial. Mr. Flanagan is an attorney the court's familiar with and has very extensive experience in criminal matters. The basis that's been offered as an offer of proof about Eric Cooksey, there are a lot of times during a trial that the defendant and his attorney may have differences of opinion about how the trial should proceed. Nothing about the way the attorney conducted his defense, in my opinion, was insufficient in this, and although that's not been raised as ineffective assistance of counsel, and I'm not addressing that issue, I don't find that there was any basis that I could determine that would justify allowing him to, in the middle of trial, on the last day of the trial, discharge his attorney who had been trying this case from the beginning, only to then have to try to deal with what would become of the trial and so forth. There was no basis given to me to indicate other than a difference of opinion. And as a result of that, I did not find that there was a basis for that. And this offer of proof today basically was all about Eric Cooksey, and Eric Cooksey did testify as a defense witness. So it seems, as state points out, to be a rather moot point. I know there are other issues that have been raised in the motion for new trial. I'm simply addressing those that are most obvious to me. I will address all of the remaining issues in the motion for new trial, the amended motion for new trial, in a written order, and that will be as quickly as I can get it done. Thank you.
Okie dokie, that took a little while, but I think it was worth it because we don't often get to see these extended hearings, and we don't always get to see a motion for new trial, and it ended about how I thought it would end, where he ruled on the obvious stuff and the rest of it's going to come written later. I'll keep an eye out. If I get updates on it, I'll of course pass that along to you. Updates aren't always forthcoming, though, as I continually point out on this channel, because a lot of court happens behind the scenes and it's not always necessarily public. So we'll see what happens there. Quick note of thank you. Over this past weekend, the channel blew through the 15,000 subscriber barrier. I very much appreciate that. It means a lot to me. The support from this community over the just short of 6 months that we've been active has just been tremendous, and it really means a lot. I know I've said that before, but I say it because I mean it. This has been a lot of fun, and I hope you guys are enjoying it as much as we are. I'm going to go ahead and leave it there for today because there's a lot of other work to do, and join us tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, because tomorrow is co-host Ellie's birthday. So at the very least, y'all got to tune in to wish her a happy birthday. Alrighty, have yourselves a great Monday. If it isn't great already, I encourage you to go find a way to make it great, because we only get so many trips around the sun, and you can't waste any day. So make the best of it. Take care. God bless. We'll see you tomorrow.